You think you understand the cost of a bad tenant. You don't. An eviction in California isn't just a headache. It's a financial hemorrhage that can drain $5,000 to $15,000 from your bank account and steal 45 to 90 days of your life. That's not a worst-case scenario. That's the average. Most of these financial and emotional tolls are preventable. This isn't about being a sympathetic landlord. It's about protecting your investment and your sanity. Before you even think about filing an unlawful detainer lawsuit, you must serve proper notice. This isn't a suggestion. It's a legal prerequisite. In California, the most common notices are a 3-day notice to pay rent or quit, a 3-day notice to perform covenants or quit, or a 30/60th day notice to terminate tenancy. For month-to-month tenancies under 1 year, it's 30 days. Over 1 year, it's 60 days. If you're dealing with a tenant protected by AB 1482, statewide rent control and just cause eviction, you need a just cause, and often a 60-day notice, sometimes even longer depending on the specific cause. The clock starts the day after the tenant receives the notice. If you mail it, you add 5 calendar days for service. Get this wrong, and a judge will throw out your entire case, forcing you to restart the process and effectively adding weeks or even months to your eviction timeline. A single error in the notice period or delivery method can cost you an additional month of lost rent, which for a $2,500 unit is $2,500 straight out of your pocket. This initial notice period, done correctly, typically takes 3 to 65 days depending on the notice type. Now here's where it gets interesting. Many landlords try to save a few $100s by drafting these notices themselves. Don't. A small mistake here invalidates the entire process, costing you thousands in lost rent and legal fees down the line. Pay an attorney or a reputable eviction service to draft and serve this initial notice. It's cheap insurance. Once the notice period expires and the tenant hasn't complied, you file an unlawful detainer (UD) lawsuit with the court. This is the formal eviction complaint. The court then issues a summons, which must be properly served on the tenant. Service of the summons and complaint is critical. It must be done by a registered process server, not you. Improper service is another common reason judges dismiss cases. After proper service, the tenant has 5 calendar days to respond to the lawsuit if served in person, or 10 to 15 days if served by mail. If they don't respond, you can request a default judgment, which can speed up the process significantly. However, many tenants, especially those with legal aid, will file an answer, delaying the proceedings. This phase, from filing the UD to the tenant's response or default, typically adds another 2 to 4 weeks to your California eviction process. Let's talk about the cost here. Filing fees alone are around $450. Process server fees are another $100 to $200. If you're using an attorney, which you absolutely should be at this stage, their fees will start accruing rapidly. Expect to pay $3,000 to $7,000 in attorney fees for an uncontested unlawful detainer. If the tenant fights it, those fees can easily climb to $10,000 or even $15,000. That's not including lost rent. If the tenant files an answer, a court hearing will be scheduled. Unlawful detainer cases are prioritized, so they move faster than other civil cases, but faster in the legal world still means weeks. At the hearing, the judge will scrutinize every detail of your case. They're looking for procedural errors you made. Did you serve the notice correctly? Was the notice period sufficient? Did you demand the correct amount of rent? Did you follow all local ordinances, not just state law? Judges in California often lean towards protecting tenants, especially in cases where the tenant claims hardship or minor procedural defects. You need to present a clear, documented case. Bring every piece of evidence, the lease agreement, ledgers showing missed payments, copies of all notices with proof of service, communication records with the tenant. A judge isn't going to take your word for it. They want evidence. But wait, there's a catch. Even if you win, the tenant might request a stay of execution, giving them a few more days or weeks to vacate, or they might appeal the decision, further prolonging the process. Though appeals rarely succeed in UD cases if you have a strong, well-documented case, this court hearing phase can add another 2 to 4 weeks to the timeline, pushing your total closer to the 60-day mark. Assuming you win your case and the judge issues a judgment for possession, the court clerk will then issue a writ of possession. This writ is what gives the sheriff's department the authority to physically remove the tenant. You take the writ of possession to the sheriff's civil division in your county. They will then serve the tenant with a 5-day notice to vacate. This is the final warning. After these 5 days, if the tenant is still in possession, the sheriff will schedule a lockout. On the day of the lockout, you or your representative must meet the sheriff at the property. The sheriff will supervise the removal of the tenant and their belongings, and you will regain possession. This final phase, from judgment to lockout, typically takes another 1 to 2 weeks. So, let's tally up the typical California eviction process. 3 to 65 days for notice, 2 to 4 weeks for the UD lawsuit and response, 2 to 4 weeks for the court hearing, and 1 to 2 weeks for the sheriff lockout. That's a total of 45 to 90 days on average, from the moment you serve the first notice to when you regain possession. And during that entire time, you are likely receiving no rent. If your unit rents for $2,500 per month, a 90-day eviction costs you $7,500 in lost rent alone. On top of those, $5,000 to $15,000 in legal fees. The most effective way to avoid the California eviction process is to prevent it. This isn't groundbreaking, but it's often ignored. Your tenant screening process is your first and best line of defense. Run comprehensive background checks. Credit, criminal, eviction history. Don't rely solely on a credit score. Look at their payment history, debt-to-income ratio, and past landlord references. Call previous landlords, not just the current one. A current landlord might just want to get rid of a problem tenant. For example, a landlord I know skipped the eviction check because the tenant had good credit. Turns out the tenant had 3 prior evictions in other states, all settled before judgment, so they didn't appear on a standard credit report. That oversight cost him $12,000 and 6 months of headache. Beyond screening, early intervention is crucial. If a tenant misses rent, don't wait. Serve that 3-day notice to pay or quit immediately. Open lines of communication. Sometimes a tenant genuinely falls on hard times and needs a temporary payment plan. But if they're unresponsive or making excuses, you need to act. Consider cash for keys. This is often cheaper and faster than a full eviction. Offering a tenant $1,000 to $3,000 to vacate voluntarily. Sign a mutual termination agreement and leave the unit in good condition can save you weeks of legal fees and lost rent. If an eviction is going to cost you $10,000 in 60 days, paying a tenant $2,000 to leave in 7 days is a no-brainer. It's not condoning bad behavior, it's smart business. In summary, a typical California eviction will chew up 60 to 90 days of your time and set you back $5,000 to $15,000, not including lost rent. Your best defense is rigorous screening and immediate decisive action when problems arise. Don't cut corners on legal advice. Don't delay serving notices. And always evaluate if cash for keys is a financially superior option to a protracted legal battle. Your profitability depends on it. Powered by LeaseBase Intelligence.